Hello everyone, I am Monalisha Padhi. I am a legal intern at LEXIS and Company, and I am pursuing my BBA LLB from Bharati Vidyapeeth New Law College, Pune, and I am currently in third year. So today's topic would be coparcenary, and the purpose for this video is to create awareness about the topic. So coparcenary is a term used in matters related to Hindu succession law. It refers to the person who has the capacity to assume a legal right in his ancestral property by birth. It means unity of title, possession, and interest. It is purely a creation of law. It cannot be created by the act of parties except by adoption. It is directly derived from the concept and practice of Hindu divided family. So, what is Hindu undivided family? Hindu undivided family or a Hindu joint family is an extended family arrangement where every member is a lineal descendant of a common ancestor. This family includes a common ancestor who is generally the eldest and the generation of his descendants. This practice can also be seen in Jainism, Sikhism, and Buddhism. This family arrangement is governed by the Hindu Succession Act 1956. It is a codified act and it is concerned with the transfer, devolution, and ownership of inherited property amongst the Hindu joint family. The act, though patriarchal, has seen a few major changes within the law withheld. At the time of incorporation of the act, it was a compromise between tradition and modernity, due to which equality could not be attained. It has now sought to redress some anomalies created by traditional Hindu law. The history of law of inheritance. The concept of coparcenary originated from ancient Hindu jurisprudence and became an essential feature of Hindu law. Within the Hindu laws, all the laws and provisions regarding the property and its rights have always been male oriented. They were exclusively framed for the benefit of the men of the family, and while women were always submissive. The Hindu Succession Act 1956. The Hindu Succession Act for 1956 was focused upon providing equality as stated by Article 14 of the Constitution of India. The idea of the limited estate as propagated by the Hindu Women's Right to Property Act was abolished in 1956 by the introduction of this act. This act tried to uplift the position and status of women in society by providing them with the inheritance of share in their father's property. Daughters were declared as legal heirs of their fathers and received the right of inheritance of a share of the separate property owned by the father through the notion partition. The ancestral property owned by the family would still be legally inherited by the son of the family, and the daughter would have no rights over it, thereby following the rules of survivorship. This led to the continuity of inequality, but at lower or less diminishing pace. Amendments within the Hindu law. It was observed that the legislation made on the topic were not able to serve the purpose of equality and hence required to be modified according to the changing needs of the society. There were further changes made to incorporate daughters within the ambit of property rights, but nothing major could be achieved. In 2000, the Law Commission report suggested reforms with regard to women's right to property. It pointed out all the clauses which supported bias towards male and suggested significant changes to be made. The Hindu Succession Act 2005. The Hindu Succession Amendment Act 2005 was enacted with the aim of expanding the rights of women and daughters of the family and bring them at par with the male members. It followed the suggestion provided by the Law Commission report. By the way of this amendment, the daughters of this family, whether married or unmarried, gained coparcenary rights with the other entire rights and liability equivalent to a son. This now meant that the daughter would also be liable for the debts and losses in addition to the property shares and other rights. Section 5 of this amendment challenged the fundamental principles of Hindu coparcenary law. Through this amendment, daughters, both married and unmarried, were given equal rights over the coparcenary as the sons of the family. It also provided that the females of the family could now also act as the karta of the family, which they couldn't previous to the law. Any reference made to a copartner would also include doctors, will also include daughters equally. Conclusion. So, hence, the concept of coparcenary has come a long way and undergone many changes. The 2005 amendment is a big step in dismantling patriarchal forces because it grants women economic freedom and challenges the notion that became a part of their family, husband's family after marriage. It is necessary to understand whether equality exists only as a phenomenon or it is actually present for the awareness and approval of the majority of the people. It should not be solely realized by placing a section of women in the tradition of inequality. Thus, there is a need to create social awareness and to educate people to change their attitude towards the concept of gender equality. The need of the hour is also to focus attention on changing the social attitudes in favor of equality by all by enacting a uniform law. Thank you all for today. This is all for the topic. Uh, Please like and comment on the video and please subscribe the channel. Thank you.